I'm very happy with the judgment, because the issue of when elections are supposed to be conducted is become a very big issue.
A majority judgment has been handed down by the Chief Justice, concurrence of 7 judges, 2 judges dissenting. It is to the effect that elections must be held by the 31st of July 2018.
I will quote MDC Secretary General Priscilla Mesera Bimshonga, who said, "We do not understand under what law the 9-member Constitutional Court was constituted, since part of the Constitution, which provides for a 9-member Constitutional Court, has not yet come into effect, and will only come into effect when a new president is sworn in after the election." So I think that's the threshold question. Was this a properly constituted Constitutional Court?
Those who have planned this case generated unintended consequences. They generated a usurpation of the executive power by the judiciary, and this could never have been their intention. So certainly it is not the power of a court to declare an election date. Not where we are following constitutionalism, as Chijausik says in his judgment.
Early this morning, I received a letter from President Mugabe dated 13 June 2013, in which he advised that in purported compliance with the Constitutional Court judgment, he was proclaiming the 28th of June 2013 as the sitting of the nomination court, and the 31st July 2013 as the election day. President Mugabe, in calling for an election where the electoral law has not been passed in Parliament, is clearly acting unconstitutionally. He is fully aware of this, hence the claim in his letter that he is using his powers under the Presidential Powers Temporary Measures Act. Ladies and gentlemen, the Presidential Powers Act, which in the past allowed the President to make laws on his own without Parliament, is patently not in compliance with the new Constitution.
The President used Section 28 in brackets 3 of the Constitution to determine that a nomination court shall sit on Thursday, the 28th of June at the High Court in Harare.
I'll be leaving tomorrow for SADC, and I will fully brief the regional leaders on the crisis in Zimbabwe.
The first thing is that the SADC Heads of State Summit acknowledged the existence of a court judgment with regards to the timing of elections, but in that acknowledgement also urged the government of Zimbabwe to go back to court and seek an extension of the period beyond July 31.
We gave a specific instruction to Honorable Minister Chinamasa that he was supposed to be filing an application on behalf of government, because there was consensus amongst ourselves that we needed to approach the Constitutional Court as a collective. A first-year law student would not prepare the nature and content of the affidavit that I'm holding in my hands. In essence, in his affidavit, which is 4 pages, he's saying, I'm coming to you to seek an extension of time because I've been directed to do so by SADC. So he's basically, I'm sorry to say this, and I wanted to avoid it, he's basically going to the Constitutional Court to say, please, can I lose?
What actually happened was that the parties discussed the application which Minister Chinamasa had prepared, and they indicated that there were certain issues that they were not happy with, and they then agreed, the 3 of them, to the preparation of another joint application. So we had taken the position, or we believed that Minister Chinamasa was going to withdraw this application, but he has indicated that he's forging ahead with it. And the moment that he indicated that he was forging ahead with it, we had to agree to it being set down on an urgent basis, because if the application is to be heard, it must be heard on an urgent basis. There's no doubt about it. And the Chief Justice had indicated that he has set down all the constitutional matters on the continuous row beginning on Wednesday.
The second and fourth respondents made an application before the court to have their counter applications consolidated and heard together with the application that was before the court.
and we objected to that. I objected to that. At the end of the day, after we presented our arguments and the respondents presented the argument for that consolidation, the court then ruled that let this matter be postponed sine die, and then which means indefinitely, but it's now a question of when.
What came out was a unanimous decision this time. You remember the last time it was 7-2, this time it was all 9 judges, reaffirming that basically the constitution of Zimbabwe prevails. And we are going to elections on the 31st, and I hope we can move on from there.
It is for the court to make a determination, and the court has made that determination. We'll have to live with it. We'll peruse the judgment when it is finally ended down. At this stage, we are not aware of what the reasons are.
Justice Chinamasa was very clear as his reasoning for appearing before the court. His reasons were very clear that in his own mind, he believes the president has complied with this court order. The president has no reason not to comply with the court order, and he's only coming before this court because he's complying with a resolution of SADC.
The position of the law is very clear that we will go for elections on the 31st.